All right. Well, welcome to the Create a Living Legacy, Eliminate the 8 Failures of Estate Planning webinar. This is an interesting way of presenting these. We're used to doing them in person. We're used to filling up the room and standing at the front and, having handouts. And this will be our first experience doing the webinar. And obviously, because of the coronavirus, we're going to be doing these for a couple months. The goal today isn't a sales pitch. It's a conversation starter. And the reason that it's so important that we start this conversation is only 42%, less than half of Americans have an estate plan. And so what I want you to do today is think about your legacy. As the title implies, create a legacy. We're really big at LifePlan, creating the legacy for ourselves, for our families, for those who come after us. And so as we go through these 8 failures, I want you to really think about what they mean to you and as part of your legacy. As a housekeeping things I mentioned, the replay, hold your questions to the end and I'll be able to take them at that point. So jumping in, finding the right page here. Let's start with the end in the beginning. And as you can see on your screen, there's a skydiver there because there's 2 things that I believe that you shouldn't compromise on. Number 1 is the person who packs your parachute when you go skydiving. And number 2 is your estate plan. And the reason that I say that is because you don't find out you made a mistake until it's too late, right? If the guy who packs your parachute before you go skydiving doesn't know what he's doing or doesn't do it right, by the time you realize that, it's a little too late. And the same thing happens with estate planning. You see, you made a plan during your life, but that plan really starts to take hold and take action after you pass away. And unfortunately, at that point, it's a little late to say, oh, I made a mistake, or I wish that I would have changed something different. So I start here, the end in the beginning, by saying this. At the end of this presentation, I offer every listener, every participant, and the replay audience an opportunity to schedule a free 30-minute session. There's no obligation, where we can walk through your situation. We can talk about what's important to you and come up with a plan that makes sense for you. And as part of being a participant of this, we're offering $500 off our Living Trust package and $350 off our Advanced Will package. So we'll talk about all of that a little bit later, but I wanted to start there just so you knew where we were going. Who am I? Well, you can see some pictures there. I've been a lawyer in Arizona for 15 years. I got a law degree in San Diego in tax and estate planning. And at the same time, I guess because I'm a glutton for punishment, I also did an MBA in San Diego in finance emerging enterprises. And what that did was it created kind of a synergy in my thinking and thought process in the way I run my business. On the one hand, I have the tax and the estate planning side. On the other hand, I look at the future. I say, what is emerging in our lives, in our businesses, that we need to take a look at? Most people hold assets in one of 2 areas. Real property, meaning a house or a condo or a cabin or some land, and then in investment properties, whether it's an IRA or an annuity or a 401k or whatever. Most people hold their assets in those 2 places. And so by marrying the Financing Emerging Enterprises MBA with the law degree, it gives us an opportunity to talk really from both perspectives. Right after law school, I did a stint with a national nonprofit. I spent 11 years working as a tax attorney. And one of my jobs was every Monday morning, I would get up, I would get on an airplane, and I would go all over the United States. And I would meet with high net worth individuals to talk about how they could make contributions, charitable contributions to the organization that I was working with. And really, as we sat down and talked to these families, these are high net worth families, one of the things that I realized is that they face a lot of the same challenges that we face. They love their families. They want to provide for their families. Sometimes you would hear, as Warren Buffett says, I want to give my family everything, but not so much that they do nothing. And so we started to look at, hey, how can we take the lessons that we're learning in dealing with these high net worth families and create a system, create a process, create a program that really benefits families that are in all walks of life. And so that's where we came up with the LifePlan Legal Family Vision, i.r.s. Family Vision, that we're going to talk about a little bit later. Just as by way of introduction a little bit further, you'll see at the bottom of the slide, Family Before Fortune and Modern Leadership. Those couple of podcasts that I started back in 2014, still running today, over 350 episodes, talking about, building the life of your dreams with the people you love. Of course, most importantly, you can see front and center on the slide, I'm a husband and a father of three. Those are my three kids. My wife hiding out in the background of the second picture there. So that's who I am. But enough about who I am. Let's jump into the reason that you showed up for this presentation. You want to hear, what are these 8 failures that estate plan or families estate planning that we've seen throughout the nation, throughout different families. So jumping into that. Oh, I get ahead of myself a little bit. Our goal today, and our goal really, not just today, but our goal as an organization is to help 1,000 Arizona families pass their values along with their valuables to the next generation. And really, I think that's what makes us different. We start with your values. I want you to hire us. There's no question about that. I want to do your estate planning. I want to do your powers of attorney. I want to do your guardianship. I want to do your probate. I want to do that. But that is not the goal today. Our goal today is those 3 things you see on your screen. If you don't hire us, I want you to walk out of here saying, that was one of the most informative and best presented webinars or workshops on estate planning that I've ever seen or attended. I want you to share this experience with your friends, with your family, even with strangers. And the reason I say that is because we can't get to our goal of helping 10,000 Arizona families if we don't get your help. So with that, now for real, jumping into the very first failure. The number one failure, and by the way, these aren't in order of importance and they're not in order of most common. What they are is just 8 things that we have seen as we look at estate planning throughout all different types of families, whether it's a single individual, whether it's a family with a lot of young kids, or some empty nesters that the kids are out of the home. One of the failures that we see is this idea of the failure to plan. And the irony is, we plan for birthdays. We plan for vacations. We plan even when we go to the grocery store. There's a scroll on the wall at my house, and my wife, she's a calligrapher, and she calligraphies the menu for the week. I mean, we know on a day-to-day basis what we're going to be eating for dinner. And yet, when it comes to estate planning, when it comes to aging with amazing, we sometimes hesitate to plan. And the reason that we hesitate to plan is, well, we don't want to think about it. We don't want to think about our mortality, the possibility that we may pass away. Or number 2, when we do think about it, it seems a little complicated. It seems complex. Or we may even think that it sounds expensive. Let's break it down simply. Most people, as they age, have a handful of goals. Goal number 1, they don't want to run out of money. Goal number 2, they don't want to lose their home. Goal number 3, they don't want to risk the health of loved ones. And let me explain that a little further. We've seen a correlation between as we age and as our health declines, that as a corollary with that, and about at the same time, we see the health of our loved ones start to fade as well if they're spending too much time worrying about us, stressing about us, or taking care of us. And so one of the goals that most people have when it comes to aging is not risking the health of their loved ones by putting undue burden or undue stress on them, which is number 4 goal of aging, not to be a burden or a stress on others. So if you take those 4 goals, not run out of money, not lose the home, not risk the health of loved ones, and don't be a burden, how can we take those goals and make a plan today that's going to be positive, that's going to impact? If those are the goals, what planning needs to be done? If those are the goals, what can we do to make sure that we have a great plan in place. We control the default. If we're in charge, we make the decisions. If we don't make the decisions, guess what happens? They choose for you. The government has a plan. One of the things I like to joke about is everybody on this, every American has an estate plan. Some of us create our own estate plans, 42%. The other 58% have an estate plan chosen for them by the government. And the challenge with those estate plans is a number of different things that we won't go into today, just briefly. The first one is it creates family discord. Number two, it takes a lot of time and money. And number three, our wishes aren't carried out. And number four, unfortunately, if we don't have a plan in place, then as we age, we don't get to age in the way that we want to. We don't get the care and the nurturing, the help around the home that we would like to have. And so that is part of the reason that we talk about this failure to plan. I've got this current client right now, and it's kind of a sad situation. The Alzheimer's Association estimates that 1 in 3 Americans right now are passing away with Alzheimer's or another form of dementia. And I've got this client, a couple of clients, 2 brothers right now that are taking care of their father. And unfortunately, their father has dementia and is not able to make decisions on his own. Further, unfortunately, they didn't have a plan going into this situation that they're in today, where they need to make decisions for his healthcare, where they need to make decisions for, he owns a home here in the Valley, and then he owns another home up in Pine Top, or a vacation home up in Pine Top. And they need to make some decisions, financial decisions about those assets, those properties, but they didn't make the plans prior to their father being diagnosed with dementia. So what that means is what they could have done through a power of attorney, they now have to do through a court-appointed guardian. And now they're petitioning the court to appoint them as the guardians. But what would have cost them $500 as a power of attorney is now going to cost them $20,000 as a guardian. Now, I wish I could say that all that $20,000 was going to me. It doesn't. There's a lot of different things that go into planning as we age. But the more we do today, the less it's going to cost us and our family in the future. And when I say cost us less and our family less in the future, I don't just mean dollars and cents. You know, I'm a real big family before fortune type of guy. I think that family and relationships are much more important than the finances and the money. When I talk about costing us more in the future, I talk about those 4 goals that we mentioned. Not running out of money. Okay, that's financial. Not losing the home, the emotional attachment or the independence that comes with having a home, risking the health of loved ones and the time of being a burden on them. So that's our number 1, the failure to plan. Number 2 is the failure to recognize the importance. And I started to tell you a little bit about this. The Alzheimer's Association estimates that 1 in 3 seniors right now is passing away with Alzheimer's or some form of dementia. But according to the Department of Health and Human Services, 70% of those over age 65 are going to need some form of long-term care. Every 70 seconds, someone is diagnosed with Alzheimer's. And the average woman will spend 3.7 years in assisted living or a nursing home. The average man, 2.2 years. Don't live quite as long, but there is a period of time that the average person is going to spend in long-term care. Now, we also do another presentation. Every other week, we do a presentation called Will Long-Term Care Wipe Out My Savings? Because this is such an important issue. The average cost of a semi-private room in a nursing home right now is about $7,000 a month or $84,000 a year. So there's a significant financial challenge that assisted living and aging without amazing is creating and causing. Now, when it comes to failure to recognize the importance, one of the things that we fail to recognize is how are we going to pay for this? There are some options. Option number 1 is we can use our savings. And I think as we've aged, that's been the number 1 go-to that we've thought about is we're going to save up, we'll have a little bit of money tucked away, and we're going to use that in case something happens. Unfortunately, at $7,000 a month for a semi-private room, those savings don't last very long. So what's another option that we have to pay for it? Borrowing from our family or taking a mortgage out on our property or a reverse mortgage. You've heard about these different types of things. A third way is long-term care insurance. Now, unfortunately, long-term care insurance requires us to start early, right? We can't go and get long-term care insurance when we're 85 years old. We need to start that when we're younger and healthier, knowing that there's probably a possibility that we're going to need it later on. And then the fourth one then is government aid. Under the Access Program or Medicaid, covers long-term care, assisted living, and these types of things. Actually, ironically, this is the fastest growing part of my business because a lot of people are concerned about how they can age and have enough money to make it through the rest of their lives. So one of the things that I recommend that you do is look at how your assets are titled. And so you may have a home. Is your home titled in the name of a trust? Is it titled in the name of your children? Is there a beneficiary deed on the property which will allow your children to take possession of the property at your passing? How about your IRAs? How are your IRAs and your life insurance policies labeled or titled for beneficiary purposes? Do you have the proper beneficiaries in the proper place? Let me tell you a quick story about this. A couple of the stories I'm going to tell you during this presentation revolve around mother-in-law, my poor mother-in-law. She's got some great stories that unfortunately have been some challenges, but make me able to present these presentations with a little more authenticity. So the first story of the many you're going to hear today deals with a life insurance policy that her mother had. So my mother-in-law's mother, or my wife's grandmother, had basically when my mother-in-law was 12 years old, her parents divorced. And her mom lived in Oklahoma and her father moved to California. And my mother-in-law went to live with her father in California. The rest of the siblings stayed in Oklahoma. And my mother-in-law's mom, her mother, ended up getting married 4 times. First time to my mother-in-law's husband. Well, as she married the second husband, she took out a life insurance policy, $10,000 on her life, named her second husband as the beneficiary. Well, a few years ago, my mother-in-law's mother passed away. And when she did, my mother-in-law was going through all of the papers and all the documents. And I know you know where this story is going, right? She finds this life insurance policy that was created like 30 years ago. And the beneficiary named on there is husband number 2. Well, husband number 2 had passed away 30 years ago. And so beneficiary to this life insurance policy was now the estate of husband number 2, which listed his kids. And we started to talk about this as a family of what the unintended consequences of how we label and title all of our assets, all of our property, all of our life insurance policies, all of our 401ks and all of this. So the number 2 failure that we see is this failure to recognize the importance of doing something. And doing something can be as simple as calling up your IRA or your annuity company and making sure that the right names are the beneficiaries in the right percentages. It could be as simple as checking the title of your home and making sure that you've got it set up straight. We can add a layer of complexity, which will actually add a layer of simplicity to your heirs later on when you pass away by doing something like a trust, where you make sure you label all of your assets properly so that at your passing, they pass easily to those that you love and those that you had intended. All right, so that is our number 2 failure. Number 3 is the failure to understand. And we started this presentation, I mentioned that one of the reasons that people don't do the estate planning process is they think that it's complicated. They think that there's so many moving pieces. And I'm a simple guy. I like to bring everything down as simple as possible. And so to take estate planning and make it as simple as possible, I say that there are 5 documents that every person needs. Document number 1 is a will or a trust. And we're going to talk about the difference between a will and a trust. But everybody needs a will or a trust. Number two, they need a financial power of attorney. A financial power of attorney gives someone, an agent, whoever you choose. It could be a child, it could be a spouse, it could be a friend, it could be a professional like a bank, but a power of attorney for finances gives that agent the ability to make transactions, to deal with your finances if something were to happen to you and you become incapacitated. For example, we have people that are going through Alzheimer's, or we have stroke victims, or we have car accidents that create a need for somebody else to put their input in making decisions. That's what a financial power of attorney does for your finances. That's number two. Number three is a power of attorney for healthcare. Same thing as the financial power of attorney. This is just the ability to make healthcare decisions for you. For example, when to give certain types of medicine and when to make changes as far as which hospital and which location. Do you want to be left in the home as you age? Do you want to be moved to a nursing home? Do you want to be in hospice or hospital? These are all decisions that your healthcare power of attorney, healthcare agent can make for you. So that's number three. Number four is a HIPAA authorization. And ever since HIPAA came out, and we're all familiar with it, nobody can get information about you and about your medical procedures without a release. And if you're ever in a situation where you can't intentionally give a release, you need to have this HIPAA authorization on hand, authorizing some people that you trust to get access to your care. So that's number four. Number five, if you choose to have a living will, different from a last will and testament. A living will is, hey, I don't want to be kept on ventilator. I don't want to be kept on some of these machines when I get to a vegetated state, or where my power of attorney or my doctor recognizes that's a very little chance that I'm going to recover functionally, brain, I'm just being held on machines. That's what a living will does. So those are the five documents: a will or a trust, a financial power of attorney, a healthcare power of attorney, a HIPAA authorization, and a living will. Now, I did mention that I would go back and talk a little bit about the difference between a will and a trust. A will is the only way that a parent can select guardians for minor children. So everybody needs a will who has minor children. But I would go further and say a will handles all of your assets when you pass away, regardless if you have minor children or not. And therefore, I think everybody needs a will. Now, if you have a trust, you still need a will. What we call it is a pour-over will. And essentially what the pour-over will says is, anything that's not in my trust when I pass away, pour it into my trust so that my trust can handle everything. You see, a trust can only handle those assets that are specifically titled and labeled and put in the trust. And during your lifetime, you may not put all your furniture or your vehicle or other things in your trust because it's complicated and it's really not necessary. What we do then is we use a will to pour everything into your trust. So that's why I say everybody needs a will. Not everybody needs a trust. So let's talk about a little difference between a will on one hand and a trust on the other. Wills are governed by state law. In every state, all 50 states, wherever you are, your will is governed by the laws of that state. So here we are, Arizona. Everything will be governed by the probate laws of Arizona in a will. A trust is governed by federal law. And so no matter where you are, it will always be governed by the same federal laws. So that's one difference between a will and a trust. A second difference between a will and a trust is a will is a public document. When your heirs file for probate, they're going to go down to the courthouse. They're going to record they're going to file your will with the clerk of the court. that's going to become a public document, and anybody can go and grab a copy of that. A living trust is private. Nobody gets to see that other than the person that you designate your personal representative, your executor or trustee, what we would call in a trust. So that's the second difference between a will and a trust is privacy. The third one is this, and this is the big one. Wills must go through probate. Trusts do not go through probate. They avoid probate. Well, what is probate? There's a lot of misconceptions and misunderstandings about what probate is. Probate is really the court overseeing the transition of assets from one person to the next person. So in the case where you pass away and you have a will, the court oversees your heirs passing those assets, whether it's your couch or your car or your house, to the next, to whoever you've designated. A trust does not need to go through probate, therefore passes without any court oversight. Now, one of the misconceptions that people have about probate is they think that probate is a tax, that the government is taking money from your estate to do a whole bunch of different things. And that's not necessarily true. Yes, there are some filing fees. Yes, the court does require a bond unless you have a will that specifically mentions that a bond isn't required. So yes, there is some fees involved, but the real cost of probate is the attorney. Because probate can be complicated to walk through all the documents and the court hearings and everything like that, oftentimes you need to hire an attorney to do it. And that's where the cost comes in of probate. So anything that we can keep from going through the probate process saves us time and money. Probate in Arizona typically takes between 4 and 6 months, but can take as long as 2 years and costs between 2 and 7% of the assets that go through the probate process. So anything that we can keep out of that, A, passes quicker, doesn't have to go through that 4 to 6 month process, and B, doesn't cost us that 2 to 7% of probate costs. So you often hear attorneys and estate planners, people like myself saying, well, the value of a trust, it's more expensive today to set up, but it costs your estate, it costs your heirs a lot less in time and money later. A will, much easier to set up, but costs through the probate process more on the back end. Now, you did hear me mention that whenever we create a trust, we always create a will to go with it. We never create a trust without a will because the trust really should only hold your major assets. Other than your major assets, everything else should be poured in through the will. And because you don't have as many minor assets, the probate process is quicker and cheaper for those assets to flip over to the living trust. Now, I know you probably have some additional questions on that, and that's where I go back to the very start of this presentation and say, free 30-minute strategy session where you can ask any of those questions, send us an email, any additional questions you have, and of course, at the end of this presentation, we'll open it up for a few questions on that. But I wanted to move on to our next failure and keep this thing kind of moving along. Number 4, failure to communicate. Now, I mentioned that when I first got out of law school, I spent 11 years traveling around the country, meeting with individuals and families and talking about the estate planning process, talking about charitable giving, talking about money and finances and these types of things. And the next 2 slides, you're going to see what I learned from that experience. The first one is this: 90% of problems in inheritance can be avoided by talking to your parents before they pass away. Or the flip side of that is 90% of problems that we have with parents can be solved if we just talk to our kids. And I know this isn't culturally the way that we were raised. Traditionally, we don't talk about finances. We don't talk about our plans. We don't talk about what we own and what we want to do. But it's so vitally important because what I have seen is that children have disagreements over the little things. Because when we pass away, our loved ones are experiencing a loss. an emotional loss and a grieving period. And because they're going through that grieving period, and now all of a sudden they're being asked questions about, what are we going to do with the house? And what are we going to do with the car? And what are we going to do with the 401k? And what are we going to do with the bank accounts? They get overwhelmed with emotion. And through the grieving process, they're not able to grieve properly. And it manifests itself in bickering, in arguing, in fights. And unfortunately, some of these fights last the rest of their lives. We've all probably heard and seen or read in the newspaper about families that just can't get along because of the inheritance process, because of what happened when their parents passed away. I was just on the phone call with a client yesterday whose parents passed away, left two children, two siblings, sisters, and they left the property to both of them 50-50. And it has created such a challenge because the kids both have different ideas of what to do. And so as the parents sit down and talk with their children before they pass away, open up, explain what it took to get to where they're at as parents and where they want to see the future go, problems can be avoided. I often joke that the number one thing that we see fights over, and maybe I shouldn't joke about this, but I do smile. The number one thing I see fighting over is mom's wedding ring. Number two is the pot that mom cooked potatoes in for Sunday dinner. Somehow there's this emotional attachment to Sunday dinner that creates this arguing and bickering. One of the things that I've seen that has been very successful in kind of doing this is having your children, your grandchildren put stickers or write down on a list what they want if you were to pass away. What's the number one thing that you would want? Is it the pot? Is it the wedding ring? Is it the couch? Is it the my father-in-law, his mother, she had done this, and there's this very valuable urn that's empty. It doesn't have anything in it. I guess it's just a vase at this point with a lid on it. But my wife always jokes that that's the one thing she wants when her grandmother passes away, because that's where I'm going to be put when I pass away. And so, take this as a suggestion to have this conversation and to start thinking about, hey, if something happens to me, if something happens to your dad, if something happens to your mom, what are we going to do to pass these items that have small financial value but large emotional attachment to the next generation? The fifth one then is this failure to include your values. And I started out by saying that at LifePlan Legal Arizona, we start with your values. This is very important to me because I have seen so many challenges in families where they just try to pass the beans. They try to pass the valuables to the next generation without taking a moment to step back and figure out what they truly value and what those values really mean. And so through this process, I created what I mentioned earlier, the LifePlan Legal Arizona i.r.s. Family Vision. And I refer to i.r.s. not as the Internal Revenue Service, but as this idea of identifying what you truly value, what's important to you, and why is it important? How did you get to the point that you value this in your life? For me, education has always been a high priority. But it's more than just saying, I value education. Why do I value education? What are the things that I experienced in my life that created this importance of education to me? And just as a quick side story, my parents were also divorced when I was 12 years old, and I went to live with my dad. There were 4 kids. My brother and I went to live with my dad. My other brother, younger brother, and sister went to live with my mom. And I watched as my mom would get up early in the morning to get my siblings ready for school. And then she would run off to a full-time job where she would work all day. She would get home just in time to make dinner and make sure that the kids were doing their homework. And then she would get them to bed so that she could spend the rest of the evening studying to get her degree. She didn't have a bachelor's degree at that point in this story. And I watched that transformation that happened through her. And I remember being a 16-year-old and getting a phone call from my mother and the invitation to come to her graduation for her MBA. And not just her graduation, but she was valedictorian. She was going to be speaking. As we start to identify what we value and not just what we value, but taking that step back and identifying why it is so important to us that we value this. Then we can go to the next step, and that is recording it in a way that will be beneficial for our heirs and generations to come. Some of the things that we do is we sit down and create a video journal or diary, or um, uh, showing of what the parents value. Well, we do a written or a audio version of this. One of the things that we include with all of our revocable living trusts is this LifePlan Legal i.r.s. family vision, where we help you identify, we help you record, and then ultimately we help you share your values with the next generation. And we do that through 5 family building activities. Activity number 1 is family fun. You might have heard the family that prays together stays together. I always talk about the family that plays together stays together. Number 2, family education, the family that learns together, grows together. Family number 3 is family business. And this isn't mom and pop. This isn't opening up a store, becoming a group of family plumbers. What this is when you pass away, your children are going to have to deal with your assets together. They're going to have to make decisions on what to sell, what to trade, what to distribute, what to donate to Goodwill. This experience of building family business mentality during your lifetime creates a smooth transition when you pass away. That's number 3. Number 4, family stories. And number 5, family philanthropy or family charity. Families that work together serving a greater good tend to stay together. So you could tell probably as we talk about this is something that I'm very passionate about. This is something I've spent the last 15 years of my career really looking into, and something that I'm very proud of as an estate planning attorney that we offer to our clients. So that's number 5, failure to include your values in your estate plan. Number 6, the failure to update. And as I was putting together this slide, I was listening to some music on Spotify, and a song called Life Changes by Thomas Rhett came on the radio. I thought it was very ironic. And the lyrics say this: ain't it funny how life changes? You wake up, ain't nothing the same. You can't stop it. Just hop on the train, and you never know what's going to happen. You make your plans and you hear God laughing. Life changes, and I wouldn't change it for the world. And it's nice to sing about, right? It's nice to think about and talk about. But the reality is, day to day, we don't know what we're going to be experiencing. We don't know what challenges that we're going to have, what opportunities we're going to have. We may win the lottery, and all of a sudden finances aren't a problem, but we have other challenges. We may have a diagnosis with one of these viruses that are going around right now, and we don't know what our future is going to hold for us. Life changes, and because life changes, we need to constantly keep an eye on, we need to often keep an eye on our estate plan and make sure that it reflects our current desires and wishes. And so one of the things that we do to make sure that this happens, this failure to update, we recommend that you sit down with an experienced estate planning attorney every 3 years and dive into what your plan is. Now, I say we recommend it every 3 years. We offer free annual and ongoing workshops that you can come and have us take a look at your estate plan, have us talk about any changes that you've had in your life, and make sure that your current plan reflects what you want currently. And the reason that I say this, and the reason I'm so passionate about this, is because I think that we as estate planning attorneys, as a group of attorneys that focus on estate planning, that we want to be your advocates for life. We want to be your trusted advocate, meaning that if you are in a car accident and you don't know who to call, you can call us and get a reference for a car accident attorney. Or if unfortunately you're experiencing a divorce or have a child experiencing a divorce, we want you to feel comfortable to call us, and we can help you make sure that you are put in the right direction with the right team of advocates that will help you. We don't want to just create documents. One of the questions I get a lot is, well, Jake, can't I just create my estate plan on my own? And the answer is yes. You can sit down at a computer. There's a lot of sites that you can look up, and for a couple $100, you can draft a will. But I caution you for two reasons. Number one is, yes, you created a will, but no, you didn't create a plan. I think you need to sit down with an expert to talk about a plan, what makes sense for your family, and not just a plan for today, but somebody that can be with you as you change, as you grow, as your priorities change, and make sure that your planning reflects that. The second reason that I discourage people from just going online and printing off a will is, as we started with the skydiving example, unfortunately, when you pack your own parachute, if you do it wrong, you don't find out until it's too late. And so, we often talk about, an ounce of prevention is worth a pound of cure. That's what I feel as far as estate planning goes. So that is number 6. Number 7, stay educated. We talk about how the laws change often. Just in January of this year, we saw the law for IRAs change. We saw that the Secure Act was released, where it made it much more difficult for families to keep an IRA and pass it from generation to generation. Because the law is constantly changing, we recommend that you do your best to stay educated. And how do we play a part in that? Well, these workshops are one. But in addition to these workshops, we do a trustee training manual. So your heirs know exactly what the next steps that they need to do are. We include it in all of our Revocable Living Trust plans, where your heirs can know, okay, mom just passed away. What do I do next? Dad is going into a nursing home. How do I make a decision moving forward? The other thing that we do is, when you pass away, your trustee gets a free consultation. They can come in, sit down with us and say, look, I'm processing this emotional loss. I don't know what to do. What does my mother's estate plan say? What does my father's will tell us to do? And so we offer that to stay educated moving forward as we go, and as the world changes and as the laws change. All right, our final one today is number 8, and that is a failure to fund. This is a very common mistake with do-it-yourself services and attorneys who do not specialize in estate planning. And what I mean by failure to fund is a trust must have an asset in it, or that trust is invalid. And let me give you a story. I told you I'd tell some stories about my poor mother-in-law. My mother-in-law, as I mentioned, lived with her father in California all growing up. Her father remarried out in California, and his new wife had 3 children. So they became a family of 4, basically, my mother-in-law and the 3 children, and now the parents, the step-parents and her dad. And they had a very loving relationship and a very successful financial career. My grandfather-in-law had a very successful career. He was an insurance agent out in California. And unfortunately, a couple of years ago, he passed away as well. But prior to passing away, in the 80s, he created, with a friend of his who was an estate planning attorney, but not very experienced in this, created a living trust, but never funded it, didn't put anything in it. So when my grandfather-in-law passed away, that trust was considered invalid. So then what happened was, they didn't know about it because his wife, my mother-in-law's stepmother, was still alive. We didn't know about the error. And then when she passed away, we found out this trust was invalid. Well, under the laws of California, her estate passed through what's called intestacy, meaning it went from her to her 3 kids. Now, I mentioned that the 4 of these children grew up together, including my mother-in-law. But because of the way that the law was stated, and because the trust was deemed invalid, she was left out. Now, we're still working on it. It's interesting because the siblings are all loving and trying to work it out. And so they're actually going through a pretty good court, I don't want to say battle, because they're not really fighting with anybody but the court system, to make it so that my mother-in-law can get her 1/4 share of this trust. That story being told, I highly recommend that you sit down and talk to an estate planning attorney who knows what they're talking about when it comes to funding a trust, to make sure that your trust is valid at your passing. All right, let me move on. Next slide. So obviously, as we come around to this point in the presentation, we have a plan for that. LifePlan Legal has experienced all 8 of these failures. We've seen it in many of our clients, and we've done what we do to make sure that none of these 8 failures come into their lives and into your lives. We focus, as I mentioned, on your values. We offer that peace of mind, that clarity. As you could probably tell through this presentation thus far, I'm very open. I'm very kind of authentic when it comes to telling you what I'm thinking, and I try not to hide the ball. I want it to be as clear and simple as possible to offer you and your loved ones peace of mind. I already mentioned the idea of becoming your advocate for life, and we adapt to you. No family is the same. We deal with second and third marriages. We deal with divorces. We deal with stepchildren, adopted children. We deal with surrogate children. We deal with no heirs. We deal with pets. How do we handle a pet when we pass away? We deal with spendthrifts, where if you have a child that you're concerned is going to get their inheritance and then go to Las Vegas, we know how to work with that. And so there is a plan for that. In conclusion and in closing, let me just say, as I started, the next step is to claim your free strategy session. Come sit down with us, do it over the phone, do it over Zoom, talk with us about your unique situation. Help us come up with a plan for you that will make a difference for you moving forward. As I mentioned, $500 currently off our living trust packages, $350 off of our advanced will packages. And as a closing thought, don't compromise on parachutes and estate planning.